Hello, everyone. This is our week 3 recorded lecture because of the university holiday that prevents us from meeting for our live lecture this week. So for week 3, we covered chapters 6, 7, 8, and 9. The first 2 chapters will focus on the rules of evidence, and they are by far the longest of the 4 chapters. So once we get through those first 2, it will definitely move a little quicker. So evidence is a huge topic. We're probably clear on what evidence is. That itself is not a difficult concept. Evidence is really anything that tends to support a version of events. Anything that tends to support some version of events is evidence of that version of events. But what are the rules of evidence? These are the rules that determine what kinds of evidence are reliable enough and relevant enough to be relied on in a courtroom, usually during a trial. Sometimes during motion hearings as well. The rules started out as federal, but then were largely adopted by individual states over time. Evidence is routinely part of both civil and criminal trials. It can take the form of physical items or oral testimony. Both are evidence. Only evidence that is admissible is what a jury may consider, or a judge if the judge is deciding the case. So if one attorney tries to elicit testimony or mention evidence that the other attorney believes violates the evidence rules, the second attorney must object and state the rule being violated. That's an objection. And then at that point, the judge must decide who is correct and ultimately decide on the admissibility of that contested piece of physical evidence or testimony. I'm sure you've seen the back and forth on television where there is objection overruled or objection sustained, and that's when this occurs. I've talked before about the standard of proof and what the evidence must show to prevail in a case. You know that in a civil case, it's the preponderance of evidence, and in a criminal case, the standard of proof is beyond a reasonable doubt. In just a few types of civil trials, there is a third standard called clear and convincing evidence, which lies somewhere between the preponderance standard and the beyond a reasonable doubt standard. It's much less common, but it's important to know that it does exist in some cases. And it's always the plaintiff who first has the obligation to satisfy that standard of proof. Whether it's a civil plaintiff or a criminal prosecutor, whoever is bringing the allegation has to satisfy that standard of proof. But after they satisfy that standard of proof, the burden can then shift. If the plaintiff successfully proves all elements of the law they're alleging, then the burden shifts to the defense. And then to prevail, the defendant now must establish all elements of a defense that excuses them from liability for their actions or justifies their actions. There are different types of defenses, both defenses that justify and defenses that excuse, but as long as it's an accepted defense, that can undermine the plaintiff's establishing of the initial standard of proof. Circling back to what is evidence. It's not really a mystery. It can be testimony, or it can be documents, or it can be other items. It can be trial aids. Demonstrative evidence is another term for a trial aid. Anything prepared for trial to help the jury understand other evidence in the trial. And they are allowed as long as they're not misleading. All of these things are things that may be used to prove a case. It's also important to be able to distinguish between first-hand knowledge and second-hand knowledge, because that becomes very important as we proceed to addressing the different evidence rules. So with testimony, when you have a witness testifying, first-hand knowledge is simply something that that witness observed, saw or heard or smelled. That's first-hand knowledge, and the witness is testifying about that. Second-hand knowledge would be testimony that the witness only knows because someone else told them about it or they read about it, for example. First-hand knowledge is absolutely preferred because testimony by a witness about second-hand knowledge is called hearsay. And in most situations, hearsay is prohibited by the rules of evidence. And we'll also talk later about why that is, what the reason for that is. We'll also revisit this hearsay rule in some depth, but for now, we're just going to keep looking at the different ways evidence can be categorized. And this is one of the ways to categorize evidence. Whether evidence is direct or circumstantial is another important observation about evidence that you just need to be able to make. It's important to know that fundamentally direct evidence is more probative than circumstantial evidence, because direct evidence directly tells you, it itself informs you of something. With circumstantial evidence, the way to identify it is that it requires you to make some inference before it has relevant meaning to the case. So there is, it could also be called indirect evidence. It just happens to be called circumstantial evidence within the legal field. But that's, again, a primary distinction you need to be able to identify as we move forward. So here's an example. A witness testifies that she saw the defendant point a gun at the victim, shoot the victim, and run. So if a witness testifies that she saw the defendant do these things, she observed them with her own eyes, and that would be direct evidence that the individual with the gun shot the victim. That testimony tells you directly what happened. A second witness testifies that he heard a gunshot, turned around to see the victim on the ground, and the defendant running away with a gun. That testimony is distinguishable as circumstantial evidence that the defendant shot the victim. It's still evidence and is still admissible because it's relevant. But there is a small inference you do have to make there, because the witness did not actually observe the murder itself. So that's just an example to help distinguish direct from circumstantial evidence. They're both generally permitted, but direct evidence obviously does have greater evidentiary value. So knowing what evidence might not be admissible and what kinds of evidence have less probative value really can inform your investigation of cases. It's obviously expected that the jury will side with the party who has presented the most probative and credible evidence. So that's the goal. So knowing what kinds of evidence are admissible and probative can help you focus your investigation, what to spend more time on, and what you're really searching for. It can help you filter out unusable evidence. It can guide you to keep searching further when needed. And it can guide you away from other evidence sometimes if you, in the back of your head, understand that that evidence that may exist somewhere that you could go looking for might ultimately not be admissible or particularly probative anyway, so maybe your time is better spent elsewhere. Understanding evidence rules can really help you weigh the value of information that you obtain both during informal and formal discovery periods. While learning about evidence admissibility, it also makes sense to include the privileges. Privileged information or communications do not have to be disclosed to your opponent. That's the purpose of these privileges. Most states have statutes that identify the applicable privileges that exist in each state. The original privileges most relevant to litigation are the attorney-client privilege and also the doctor-patient privilege. But it's important to know only the person who holds the privilege can agree to waive it. And in those examples, it is the client who holds the privilege or the patient who holds the privilege. Only they can agree to waive that privilege if for some reason it benefits them to allow that information, that privileged information, to be used in court. Other privileges developed over time. The work product privilege asserts that the ideas and thoughts of case attorneys that they have and write down during their trial preparation are not disclosable during discovery because that's privileged information. It's the thoughts and ideas and theories of attorneys, and they can't be expected to keep those in their mind or memory. And just because they write them down, they shouldn't be subjected to being automatically disclosed to the opponent. So that's the work product privilege. In non-criminal cases, there is a spousal privilege that allows the withholding of private communications between spouses. That's a spousal confidential communication privilege. There's the long-standing Fifth Amendment privilege, which also technically fits into this category. A defendant cannot be compelled to provide testimony in his own case. Another interesting privilege is the priest-parishioner privilege. I don't see that on here. But in some instances, a priest cannot be compelled to disclose what a parishioner told him or her in confidence. And your book does talk about this clergy parishioner privilege a little bit. So knowing these privileges also helps inform your investigation of a case, right? And your understanding of what information will or won't be usable in court. So it'll help you organize your investigation and direct your efforts away from such information that even if you were able to obtain it in some way, you may not be able to use it in court. So it's not particularly beneficial. And that's basically a summary of Chapter 6. And I'll just keep moving because I know a recorded lecture is sometimes tough to stick with, so I'll just keep it moving as much as I can. In Chapter 7, we continue to explore some of the most common evidence rules specifically, and we'll look at them in more detail. So this one does get pretty technical, but this is really important information to understand, honestly. At a baseline, before any other rule of evidence is considered, the question must be asked whether the evidence that a party wants to proffer is relevant to this case. That is, does it have probative value in this case? Does it make a determination about any of the facts in dispute in this case any more or less likely? And that's what relevance means. There's a definition in Federal Rule of Evidence 401. Does it have any tendency to make an issue in the case more or less probably true? And it doesn't have to do so in a significant manner. It's not a matter of degree. It's simply, does this give us any information at all about any of the facts or issues in dispute in this particular case? If so, that evidence may have relevance. In rare cases, usually of extreme graphic evidence, there's an exception to this relevance rule where sometimes relevant evidence may be kept out by the judge. Rule 403 can allow exclusion of relevant evidence if its potential to prejudice the jury outweighs its relevance. Again, this is usually extremely graphic evidence that's really supplementary or extra. For example, if testimony and medical records clearly prove that the murder victim in a case was brutally stabbed dozens of times, brutally stabbed to death, the medical examiner testimony clearly establishes that, witness testimony, plenty of evidence establishes that, reports. If the prosecutor wants to show the jury an extremely graphic photograph of the deceased victim, that's just kind of extra. The prosecutor might be doing that to tug at the heartstrings or the emotions or something of the jury that is not the goal of the justice system. Fair and impartial examination of evidence is the goal of the justice system. So if it's already clearly been proven that this individual was stabbed to death very gruesomely, the judge may exclude certain photos of that murder victim, even though they perhaps have some relevance, of course. Their prejudicial value might substantially outweigh that probative value, because the probative value is minimal if all of the elements of this murder have been established through other less gruesome evidence. So that's sort of how Rule 403 works. And most of the time, that's the situation in which it would be applied. You can't offer evidence just for its shock value if there's plenty of other evidence that establishes the same legal issues. There are some other smaller rules of evidence that are discussed next in the textbook. Subsequent remedial measures is a type of evidence that is generally not admissible, and here is why. So let's say you have a theft case and someone goes into a grocery store, steals a expensive steak, and walks out of the grocery store and immediately gets caught by the grocery store security. If they immediately pull out $30 and say, "Here, I'll just pay for it, let me go," they've already committed the crime. What the grocery store decides to do at that point is up to the grocery store. But if the grocery store wants to prosecute this person, maybe they have a repeated history of shoplifting there, or for whatever reason, the grocery store was in fact victimized and the crime did occur, the defendant's offer of paying for it after the fact, again, is generally prohibited because it really doesn't speak to the elements of the theft. The theft already occurred. And maybe it shows their remorse and it can be used in a sentencing hearing, but to prove the elements of the theft itself, it's not relevant. Similarly, settlement discussions in a civil case or in a criminal case, if there's negotiations going on in a formal setting, in a meeting, and one of the parties to the case kind of makes an admission or says something that could be used against them in the case that might help prove that they committed a wrongdoing, if it's said as part of good faith negotiations to try to get the case settled or plea bargained in a criminal context, those types of statements are essentially privileged because we don't want to prevent good faith negotiations from happening. The goal is to, if there's a potential for a settlement in either type of case, we don't want all of the parties being overly concerned about what words come out of their mouths in those negotiations, and the other side trying to be hyper vigilant, listening for anything that they can use against the other side if the negotiations fail. So that's the reason for that particular rule. The third example is sort of like the first. If you run into somebody with your car recklessly and then immediately offer to pay for their medical bills, that's really nice and can be used ultimately in your sentencing hearing to argue for a reduced sentence. But if you already committed the reckless driving and ran into somebody, those elements already happened. And those statements after the fact generally are not speaking to the elements of the law at issue. As you can kind of see, these all have similar reasoning. They're just each specific examples of types of prohibited evidence that can be brought in. So before we go further, just kind of to step back, our baseline that we talked about is, at the very least, all evidence must be relevant. Everything after that kind of builds onto that. But we always have to ask that question before we take the next step. Moving on to witnesses. Witness is called just to talk about what they observed or heard or saw, or what they did related to a case, are called lay witnesses, and they are distinguishable for that reason from expert witnesses, which we'll get to. The only real rule for a lay witness is to testify about relevant information is that they are competent. They are able to understand questions, truthfully respond to questions. Someone with an extreme uncontrolled delusions, like a mental health issue that leads to uncontrolled delusions, might not be competent to testify in a trial. someone with a severe brain injury that impacts their ability to comprehend and speak may not be competent to testify. But beyond that, most adults who can understand and answer questions are going to be considered competent to testify as lay witnesses in court proceedings. An expert witness testifies in a specific field. There are several more requirements for expert witness testimony, but they're brought to testify about specialized information that they know by virtue of their expertise, based on their education, their experience. And this is the kind of information and conclusions that would not be known by lay witnesses. But before expert testimony, the expert always has to be approved by the judge or agreed to by the opposing counsel. But let's talk about what is required for a judge to approve someone as an expert for purposes of expert testimony. The side of the case that is introducing this expert and asking for this expert to be approved has to make a showing that this particular witness and his or her conclusions are generally accepted by his or her peers within that area of expertise. And so there can be an entire hearing on this issue where the proponent of that expert establishes those things. And then the opponent, if they feel justified, can try to discredit those credentials. But that hearing generally has to occur, and the judge is the one that makes that decision, which is kind of interesting because a judge is not an expert on anything other than law, but they are asked to make this decision based on a hearing to determine whether someone's an expert in medicine or epidemiology or insects. I mean, anything. It could run the gamut of disciplines. Okay, so we are going to dive fully into hearsay. And you kind of have to get the beginning of it and understand the beginning of where we're going to fully understand where we are going, because it fundamentally rests on this idea. Everyone pretty much knows that you can object to hearsay, that hearsay usually can't be used in court, but people often have a common misunderstanding or misconception about what hearsay is. So our legal definition is that hearsay is when someone testifies about what someone else said to prove the truth of what that other person said. Both of those prongs must be met. So if the witness on the stand, which also can be called the declarant, says something that they know because they were told or read it, and they are testifying to those words, trying to prove the truth of those words, that's when you have hearsay. You will see as we go further into this section that there are times that you can testify to the words of others if that testimony's purpose is not to prove the truth about those words that someone else said, but to use those words for some other relevant purpose. Which, when we get there, examples will definitely help clarify that. One example that I like to kind of mention here, and I might revisit during the discussion, just sort of helps clarify one way in which this can occur. Say that you're a university town, a college town, and there's a landlord who's talking to a student who's looking for an apartment, and the student comes and talks to the landlord and brings a friend with them. If the landlord offers to rent to one of those students, and the student accepts the terms of that rental offer, but later the landlord wants to claim, no, they never made an offer to rent the apartment to that student. But both the student and the student's friend heard the landlord make that offer. Like, say the landlord said something like, if you pay $900 the first of every month, this apartment is yours. Generally, real estate agreements and leases have to be in writing, but for purposes of this example, that's not what we're going to focus on. We're going to focus on the fact that those words were spoken by this prospective landlord. If it becomes an issue and the student brings that to court because the landlord later is denying saying those words, the student and the student's friend can testify to what the landlord said. Now, they're not testifying in court to prove that he did in fact, that he does in fact charge $900 for that apartment. That would be the truth of that statement. But that statement itself was a legal offer. So if someone says words that become a legal offer, then those words serve a legal function, regardless of what the words are, beyond the fact that they were sufficient to make a legal offer, and that establishes that upon the student's acceptance, a contract was formed. That could be evidence in a breach of contract case. So that's just sort of one example that the legal function of those words could allow them to be offered into evidence, not to prove the truth of the amount of rent or the apartment in question, but to prove that the student heard a legal offer and responded to that legal offer, if the landlord is now denying that even occurred. That's just one of many examples that we'll visit. But keep in mind that if words constitute a legal act or a legal function, they may be admissible for that purpose. Again, hearsay defined is an out-of-court statement used in court to prove the truth of what it asserts. So when a witness testifies as to someone else's words, how do you determine if it is hearsay based on that definition? The easy step of the inquiry, of course, is whether that statement was out of court. Did this witness hear or read something outside of the courtroom today? And that's what they're trying to testify to. That's the easy check off that element of this particular test as met. That's the easy part. Was it a statement? And that can be oral or written. And was it initially made out of court? Where the determinative inquiry usually occurs is deciding whether the statement is being offered to prove the truth of its contents. And that's where an entire body of evidence law and hearsay cases emerged from. And that's where the landlord-student example hinges as well. We know that it was an out-of-court statement. It was made probably in like the lobby of the apartment complex. We know it was a statement because it was spoken words. Those are the easy parts. The next part is, what is it being used for in court? Sometimes out-of-court statements may be admissible if they are being offered for a purpose other than the truth of their content. So here are some more examples, other than the legal purpose of sort of a offer to enter into a contract that we talked about. The first one says to prove the declarant's state of mind. In this situation, the declarant refers to the person who made the statement outside of court. So, for example, if someone claims to be an alien and someone else overhears that claim, and then the person who overheard that claim wants to testify in court, well, Bob claimed to be an alien the other day. If that's not being used to prove that Bob is in fact an alien, but being used to prove that maybe Bob isn't competent to testify or has some kind of mental issue going on, that's a purpose other than the truth of the out-of-court statement. So that one's pretty easy to identify. Number 2 says to prove the state of mind of one who heard the declarant. So an example here would be if someone told you that Bob was hard of hearing and something came up in the trial that it appeared that you were yelling at Bob, and maybe there's like a dispute between you and Bob about something. You can testify as to the reason I was yelling at Bob is because minutes before that, our coworker told me Bob is hard of hearing and doesn't have his hearing aid today, so you need to talk loudly. That would explain why that particular witness was yelling at Bob. And the person who allegedly shared that information about Bob being hard of hearing could also be brought in to either support or contradict that claim, because it's not for the purpose of whether he is in fact hard of hearing, but it's for the purpose of trying to explain why the witness was yelling at him. Number 3, we're going to skip because we'll actually address that one in detail on our next slide about inconsistent statements and how that allows the use of out-of-court statements in some cases. Number 4 says to explain why the declarant or another person subsequently acted as they did. So an example here might be that police could offer that the dispatchers told them that on the way to a scene, the suspect was armed and violent and very unpredictable, waving around a high caliber gun. If the police need to explain why they arrived on scene in the manner that they did, maybe they arrived with guns drawn, that information can come in to explain why they acted as they did, why they didn't just roll up on scene, walk up to the door, knock on the door, but instead arrived on scene, shielded themselves behind their vehicles, had guns drawn. That was based on what they were told by the 911 dispatchers. So that information can be used to illustrate the subsequent behavior of the officers based on that information. Not necessarily the truth of the content, but why the police behaved the way they did. And then number 5, we kind of already discovered or discussed with the landlord example, where there's independent legal significance of those words of offering a contract, offering terms of a contract. If you say these specific key words and then someone accepts that proposition, you may have entered into a contract, and there's a whole body of contract law on that as to what those words need to be. But those words themselves have legal significance and may be admissible if that's what the litigation is focused on. Another example of out-of-court statements being used for purposes other than the truth of their content is impeachment. So we're still talking about statements made out of court that normally you wouldn't be allowed to testify to. But if used to impeach a witness's credibility in a certain way, those types of statements aren't necessarily being used for their truth. And if that's the case, they they may not be hearsay, or they may not be considered hearsay when being used for impeachment. So let me give you an example to explain what that means. If there's a witness that goes on the witness stand and testifies that the defendant is not guilty, I know the defendant is not guilty, but this person previously gave a sworn statement to police stating the exact opposite, something to the effect of, yes, I saw him commit the crime. The prosecutor may use that witness's prior out-of-court statement to establish that that witness gave inconsistent statements. So the witness probably, let's say they won't admit that they gave that out-of-court statement. A police officer who took that statement initially can be called to the stand and can testify that this witness, 2 months ago, gave a sworn statement that they did in fact witness this defendant commit the crime. And now in court, they have made a 180 and are testifying as to the opposite. You can't use the out-of-court statement to prove its truth because the jury has now heard two conflicting statements. So all that really does is make that witness sort of a wash. They're not credible, and that's the goal. That's no longer a credible witness for either side, but that's better than the alternative, and allowing that witness to now support the defendant and not being allowed to use their prior inconsistent statement, because it's considered, if that out-of-court statement was originally reliable, taken in a reliable manner, or overheard even in a reliable manner, there's no reason to not allow it to be used simply to conflict with the current words that are being spoken by the witness, because that does speak to that witness's credibility. So those are just some of the ways that out-of-court statements can be admissible in court if used for non-hearsay purposes. So that's what we've talked about before. Things that by definition might be hearsay but are being used in court for non-hearsay purposes. Over time, evidence law has also come up with additional exceptions to this hearsay rule. Again, the hearsay rule is that hearsay is not admissible in court. But some exceptions have developed over time, generally due to the fact that some types of out-of-court statements are reliable for other reasons, and you don't really question their reliability, and that's the whole purpose of keeping out one of the purposes of keeping out hearsay. So the first example, or a couple of the examples in this bulleted list, refer to when a verbal statement is almost an involuntary reaction. If someone yells out loudly, "Ouch, you just shot me," immediately after being shot, the prosecution is allowed to use those words to show the victim's immediate reaction to the event. Because if in the very moment someone is shot and probably hits the ground and they're shrieking these words, "You just shot me," the idea is that they didn't have the time to cognitively stop and think of making a false allegation. Those words tend to be credible because they're almost considered involuntary. When something shocking happens to you and you respond, and it happens to be a response in words, the idea is that the brain didn't have enough time to stop, think about saying something false, and then respond in a false manner. So those types of reactions are considered to be generally credible and admissible as an exception to the hearsay rule. And there's another out-of-court type of statement also that are deemed trustworthy and admissible. It says business records. Oh, here it is. Statements made for the purpose of medical diagnosis. So first we sort of have to assume that HIPAA got circumvented and somehow, or a court order allowed intrusion into medical records. And now we have these medical records. And so we have statements made to a doctor by a patient. If you can get those records, they may be admissible as an exception to hearsay, and here's why. The rationale is that if you're seeing a doctor to get treatment, and most people want accurate treatment, and you believe your words are privileged, those two facts tend to indicate that your words to your doctor are more likely to be truthful than untruthful. So the reliability of those statements to your doctor when you're in pain or injured and wanting treatment, they're likely to be true, and you may also be under the assumption that they're privileged. Those things support the credibility of those statements to medical staff. So in some cases where there's access to those types of records and those types of statements, for those reasons, that type of statement for purposes of diagnosis or treatment are considered credible enough to be used in court and exceptions to the hearsay rule. Similarly, certain types of records just kept in the ordinary course of business may be admissible. That doesn't really prevent the opposing party from trying to prove that there might be an error in those records, but normally kept records aren't going to be, or routinely kept records generally aren't going to be infused with intentionally misleading information. That would take, a really long planned crime. And it's hard to come up with an example, but the clerk of court may keep a photograph of all speeding tickets that ever came in for the last several decades, and they're kept in the ordinary course of business. It's just the Xerox copy or the original of a speeding ticket. There's no reason to believe that anything has been altered on those records. And so those records can often be entered to prove the content of what they contain because they are credibly kept. There's no reason for that particular organization or business or government body to try to alter those records. In some rare situations, if the person who made an out-of-court statement that a case witness wants to testify about is unavailable to testify, then the court might allow the hearsay of a witness. So if the person who said the thing out of court, the declarant who said something outside of court or wrote something outside of court, if they are unavailable to testify, in some situations, someone else may be allowed to testify as to what the original person said or wrote. But this is very narrow. Unavailable in this context is extreme. So if an attorney is trying to get hearsay admitted under this rule, if that attorney in any way could have gotten that out-of-court declarant to come to court, like they know that they're hiding out in Alaska somewhere. Well, the attorney needs to go to Alaska, subpoena that person, and bring them to court to testify because they're not unavailable. Unavailable really means the declarant is fully missing or fully deceased or fully incompetent at this point. That's about how narrow that is. So you can't just say, well, they moved from their last address, so they're unavailable. No, the court expects you, as an attorney and law firm who has access to private investigators and lots of records, to go track that person down. They're not really unavailable. So that's a tough hurdle sometimes. So these are even more a variety of exceptions to the rule that hearsay statements are not admissible. So while that is the rule, just remember we covered several slides of exceptions. And so it's not surprising that there are common misconceptions as to what hearsay is, because it is one thing, but it has a number of exceptions that, unless you study law at the college level, you're not going to know that these exist, and you may go on thinking that hearsay is hearsay regardless of all of these other things that we talked about that might lead to credible testimony, even though it meets the technical definition of hearsay. You can always chart them out when you're reading the textbook if you want, sort of name them and write a little definition of what each exception is. There are some study aids that are made for law school that are nice evidence rules study aids that kind of list each rule and each name of the most common evidence rules and hearsay exceptions, because you can't memorize all of these things, but it's good to be able to recognize them. So now if you're reading a case and you see that there's an out-of-court statement mentioned in one of your witness interviews, you can sit and think for a little bit. Is there any exception that allows us to use that in court? And it's kind of a fun activity to go through those exceptions and see if it fits. It's like a puzzle. So one of the reasons that we talked about that hearsay is generally not allowed in court is that oftentimes it's just not reliable. You know, somebody could testify, well, you know, Bob told me that he kicked his dog. Anybody can say anything they want. And the only way to disprove that, well, you can't disprove that, because then it becomes a he said. Bob could testify, no, I didn't. But there was nobody else around in that conversation. So there's just no probative value there. It kind of cancels out. And there are situations where it's even less credible than that, but it doesn't really help prove anything to the standards of proof that we need in court. But even beyond that, our Constitution is another big reason that hearsay is not admissible. So let's look at the words of the Confrontation Clause in the United States Constitution's Sixth Amendment. The words say that in all criminal prosecutions, the accused shall enjoy the right to be confronted with the witnesses against him. So if a witness is allowed to testify about what someone else told them, and that someone else is not there in court, then the defendant cannot confront the person who actually said the words. The defendant could say, could confront the witness, but the witness just has to say, well, I don't know why Bob said those words. You'd have to ask him. Well, he's not there to be confronted. And the Constitution guarantees us the right to confront witnesses who say something that incriminates us. And by confronting, that means we have the right to cross-examine them, to see them in court, and to ask them questions if we wish to. And that's how hearsay violates this confrontation clause, if the hearsay is testimonial in nature. If it's not testimonial in nature and serves those other purposes that we talked about in the exceptions, the courts have said it doesn't necessarily violate the confrontation clause. So for example, going back to the landlord example, we're not trying to prove that the landlord really intended, we're not trying to prove that the landlord charges $900 for that particular apartment. That would be the truth of his words. We're trying to prove that the landlord made a legal offer, an offer to enter into a contract. And so examining the words that the landlord used is considered non-testimonial in nature, because we're not asking the people who heard those words to testify to their truth, just to their impact, their legal impact on a dispute. And also in the last few slides, if you think about the other examples we talked about, not just the landlord example, you'll also see the same thing. If it's not testimonial, then it really doesn't violate this confrontation clause. Now, there are people that disagree with that, but there's a little bit of logic to that. So it's kind of open for dispute, but it's a long-standing, many of these hearsay exceptions are long-standing and pretty well accepted. Another example is, think of a deposition. So a deposition is an out-of-court statement, right? This kind of helps illustrate the whole confrontation clause. In some civil cases, even before the case goes to trial, the opposing party may want to question your witnesses. So in some cases, they're allowed to request a deposition and then meet with your witness in a conference room, and you will be there as well, or someone from your firm will be there to observe and take notes. But the opposing party questioned that person in the deposition to the extent that they wanted, were allowed to cross-examine them. If that particular individual becomes unavailable for trial, testimony from a deposition may be admissible. And it's not that it's not testimonial, it's clearly testimonial, but the defense had their right to confront that witness. It just happened to be in a deposition rather than in the actual trial. They brought that on. They had the right to confront that witness during that deposition. And so they're not being deprived of, in that particular situation with that particular witness, they're not being deprived of their confrontation clause rights. So character evidence, first let's kind of simplify. Character evidence is generally not admissible in criminal court, and it's generally more often admissible in civil court. There are exceptions both ways, but that's sort of an underlying thing to remember. Rather than talking about the section on character evidence in the textbook, I just recommend when you read it slowly. It makes sense, but there is a lot of splitting hairs when it comes to character evidence. It seems it's just it's like a fine-tooth comb. Something very similar to something else might be allowed, but there is a very specific reason why one is allowed and one type of testimony is not allowed. Essentially, just recall that the plaintiff must prove the elements of the law at trial. They must prove their version of a dispute and the fact that the law benefits their version of a dispute, right? Other things are not relevant. So character evidence is the character of the opponent is never explicitly going to be one of those legal elements. So that makes the question arise, how is it ever relevant? So when we're thinking of criminal law, yes, the state must prove the plaintiff did something bad on the day in question, did something bad. But the prosecutor is not allowed to rely on evidence that this suspect, this defendant, is a bad person, has a bad character. For many prosecutions, you just can't do that. You can only prove that on that day, this person did a bad thing. I can't just prove this is a bad person. Of course he did the thing. So that's why character evidence often is not admissible in trials for proving guilt. In sentencing, that's a whole different ballgame. But for purposes of proving guilt and protecting the constitutional rights of the defendant, it's generally a no. But then you've got Federal Rule 406. Routine actions are different if they are relevant. So that's why I kind of talked about splitting hairs. You can't testify that someone's a bad person, but for example, let's say there's this defendant who always stays out late at night carousing on this one street, the worst street in town, the street known for all kinds of bad behavior, and he's always there walking around. You can have people testify that he is always out there every night until all the bars shut down, if it's relevant to your case. If something bad happened late at night on that street, you can testify to his routine behavior. You can't say, he's a bad person, or you can't testify to his character generally, but if you can identify those specific acts, specific behavior, that's where the hairs are split. You can testify to where he is, what he does, how he's always seen there. If it's relevant to the incident date of the charged wrongdoing. That he carouses at that location late at night is different than just saying he's a mean drunk. So it's very important how you try to introduce evidence to make sure that it satisfies the evidence rules, because sometimes you might be able to use things that maybe kind of point to the fact that someone has a bad character, but you're really using admissible evidence of habits or their routine practices that are relevant to your specific case. So I'm not going to talk about the whole character evidence section because it is interesting, but it's definitely something you have to read closely and slow down to see how those hairs are split. Now, if a defendant or his witnesses testify the defendant is a perfect citizen, then for impeachment purposes, character evidence can be used just to dispute the assertions that the defense made that their client is perfect. And that's because the defense opened the door to the issue of character. Most of the time, the defense is going to know better than to do that. If they have a bad actor or somebody with a bad reputation, they're not going to allow that person or their witnesses to get up on the stand and testify how perfect that person is. They stay home every day, go to church every Sunday, never go out and party, because immediately that opens the door to impeachment. And that prevents dishonesty, right? So that's kind of an exception, but it really connects with what we talked about before about allowing impeachment to prevent dishonesty. One other exception relates to specific cases where deception is an element of the law, like fraud cases. So down on the last bullet point, you see Federal Rule 609. So for example, in fraud cases, if a defendant is charged with a crime of like fraud, and everyone in the community knows this person to be a dishonest person, and they all have had interactions with this person, and he is known to be dishonest, that's an element in dispute. So very specific crimes automatically put character into the required elements. So that is a pretty narrow exception, but laws where dishonesty and deception are part of the elements kind of open the door if the prosecution has evidence that this person simply is a dishonest or deceitful person, and that is well known and establishable by otherwise admissible evidence. Also, there is 404B. It's mentioned in the third bullet point here. This is another section to read really carefully. It's called the prior bad acts exception. The use of evidence of prior bad acts, which is, again, normally isn't something you did in the past, isn't usually allowed to prove what you did this time. There are certain exceptions that are very narrow that are permitted under 404B. And if you've ever watched like Criminal Minds, if there was a prior string of cases where let's say a thief left a particular trinket or left a particular mark on the scene, that is something that is different than necessarily saying that because they did it before, they'll do it again. If there's a certain way they've always done it, and there's no question that it was somebody else, it's a hard one to explain, but I honestly think that the textbook does a pretty good job. If you take the time to read about it, it's just so that you can distinguish that because someone's been bad before, generally, you can't use that to prove in trial that they were bad on the specific day and in the specific way you are charging them with. But there are specific, unique characteristics of prior bad acts that you are allowed to use because they tend to be trustworthy. And then the last very specific exception, let's see if it's on here. Okay, it's under the last bullet point. In the bullet point that we talked about dishonesty, another exception that's allowed is just showing proof that a defendant who testifies in court is a convicted felon. So it's a very specific exception to this rule against character evidence, but it permits the use of a prior felony conviction or conviction of a crime of dishonesty against a defendant. So if someone testifies that they were wrongly accused, for the last 9 years they have been a model citizen, the prosecutor can still say, but 9.5 years ago you were convicted of a felony, right? And they have to admit it. They can't deny it because there's a certified document showing they were. But it's kind of an arbitrary rule. It's a 10-year rule. If you were convicted of a felony 11 years ago, it can't be used against you. So, and this rule has never been successfully overturned, but I guess the idea is that a felony conviction is more than just bad character. It was proven beyond a reasonable doubt in a court of law, and so it's considered credible. And it's allowed to be brought up if a defendant testifies. If such a conviction is more than 10 years old, it cannot be brought up. But again, it's just kind of arbitrary. I don't really know how I feel about it. There's lots of elements involved in that. It's an interesting topic to debate, honestly. But I think the only thing that bothers me is just the arbitrariness of the 10-year rule. Is there something that shows that after 9.5 years or after 10 years, a person is more likely to have fully left their life of crime behind them than someone who's been crime-free for 9 years? I don't know. I doubt that exists. Regardless, these rules that we've been talking about and their exceptions don't change very often. There have been evidence rules overturned over the years, but the ones we've talked about have been around for a long time and remain in full effect and enforceable. So we talked about, we already talked about this a little bit, using impeachment. We talked about it, how it's essentially an exception to the hearsay rule, because when you're impeached with your prior statements, your out-of-court statements are necessarily being brought into court. There is also just a rule itself that talks about impeachment and how impeachment is allowed in multiple ways, not just prior inconsistent statements, but it reminds both sides to a case that you are welcome to impeach any witnesses that come to testify, because we're looking for the truth, right? So if there's another way that you can refute something the witness is testifying about, or trying to show the jury that this witness isn't really believable. So we talked about prior inconsistent statements already, but the first bullet point mentions the word bias. So maybe someone never said anything inconsistent with their testimony, but what if that witness has a familial relationship to one of the parties in the case? Is it fair for maybe the jury to know that? Because if I'm in court testifying that my beloved child could never do something like this, I know they didn't, I was with them the whole time. Plenty of folks are going to lie for their children, even in court. I mean, that's a strong bond. And the jury has the right to know if there is that type of relationship between the witness and one of the parties in the case. So you're allowed to bring up a relationship that may potentially show bias. So the jury can consider that in considering the larger picture of all the evidence and all of the dynamics involved. Or if there's a familial relationship to one of the arresting officers, if a witness has a relationship to one of the arresting officers in the case, that's important. There could always be some type of either intentional or unintentional bias involved in testimony. It's up to the jury to determine whether they think that bias exists or is significant enough to result in dishonest testimony, or just that they know about it. It's a fair topic. And not just familial relationships can show bias. Let's talk about an employer-employee relationship or a romantic relationship. Lots of relationships can cloud how someone chooses their words in testifying as a witness. And it's something that the jury is allowed to know to help determine the veracity of every witness they hear. Let's say, for example, and I don't know if that's in this particular section or another section, I may already have brought this up. If there's a lawsuit for wrongful termination of a job, and the boss is saying, well, you know, she showed up to work drunk that day, that's why she was fired. And then a former coworker of that particular person who was fired testified that, yes, I saw her show up to work drunk that day. It's fair to ask that person and find out, did you benefit from the termination of the plaintiff? Because there's some bias. If that plaintiff gets their job back, that witness may be demoted, for example. Lots of different types of bias, potential bias, not even real bias, but the potential for bias is a fair topic to investigate when examining and cross-examining witnesses in a case. Physical objects of evidence. So now we're kind of moving away from testimony. But physical objects sometimes have to pass an additional test other than relevance. Hearsay often is not going to be an issue. Sometimes it will, if the physical evidence has words on a page. But if we're just talking about photographs or, a murder weapon, Hearsay is not an issue, but there are other issues, and authentication is the legal concept that kind of controls that issue. So if a prosecutor displays a gun in court and claims that was the weapon found on the scene, the court says that's not enough, especially if the prosecutor says, and the defendant's fingerprints were found on this gun. That's very important evidence. But the prosecutor must authenticate that gun before the jury can consider it. The prosecutor has to show, and usually by records that establish what's called a chain of custody, the prosecutor has to show that that is exactly the same gun that was retrieved from the scene, how it was retrieved so it would not be contaminated, and how it was stored so it would not be contaminated. And then how it came to court that day. That's the chain of custody. So witnesses who handled and stored that object have to come to court, testify to that chain of custody in order to authenticate that physical evidence. It's a lot of work sometimes, but as long as a law enforcement agency has set procedures, and they do it routinely, it usually isn't a problem, but that is required in order to prove that that is the actual item of evidence that it is claimed to be. Photos and some documents don't require necessarily the same chain of evidence or the chain of custody, because if a witness can look at something and verify its accuracy, and that it is what it claims to be, that's sufficient authentication for like a photograph. If the prosecutor shows a witness a photograph and says, is that the bruise that was caused by the defendant 6 months ago? And the witness can say, yes, that photograph is of the bruise that was caused by the defendant 6 months ago. Obviously, the bruise itself is gone. And it's reasonable to believe that that witness can look at that photo and recognize what's on it, right? But if you're just talking about a standard gun that has no special identifying marks, and thousands of them or more are produced every year, that's why that type of physical evidence requires the chain of custody. Because there's nothing to say that it wasn't some other gun that was brought into evidence, or that it was contaminated on its way to the police department. And that's really important for rights to be protected, that those types of evidence are authenticated. Photographs and those types of things that can be readily identified by the witness without any really ability to contradict them. I mean, the defense attorney can claim that the bruise was from something else, but they can only ethically do that if they have proof to that. And if they don't, there's not much you can do once a photograph is identified. There are generally evidence rules about very common documents like birth certificates and driver's licenses. You're allowed to recognize a picture of your own driver's license or a Xerox copy of your own driver's license to be entered into evidence if it's relevant. You don't have to enter your actual driver's license because they're just such common documents. They tend to be reliable, and if it's modified, it would be obvious to anyone. Another important rule of evidence is called the best evidence rule. And this is might seem the opposite of what I said about the driver's license. But again, the driver's license is such a common document and recognizable document that unless the whole case is based on it being a fake ID, then it would obviously have to come into evidence. But if we're just trying to establish someone's identity or address or age, then a photocopy of a driver's license is going to be admissible. But there are other types of evidence that the best evidence rule applies to. The best evidence rule says that if the best evidence of something is available, then that is what needs to be proffered in the courtroom. So here's an example that makes it pretty easy to understand when that would apply. If you have a trial on a dispute about a breach of contract, if one of the witnesses testifying that, well, our contract said that, the contract that we signed said that he would pay me every 2 weeks in the amount of $2,000, and I've never been paid, and so he violated the contract. That testimony is not going to be allowed because the written contract itself is the best evidence of that information. So the parties have to produce, if there is a written contract, they have to produce the written contract. And that document comes in, and that document is allowed to be entered for its truth because it's the best evidence of a legal contract. Now, if there's a dispute about the meaning of the words or the interpretation of the words, which is usually what a breach of contract is all about, that testimony can come in, but the terms of the contract speak for themselves, and those terms can't come into court just from the testimony of the parties, but they need to come into court through that best evidence of the contract itself. So that's just one example of when the best evidence rule applies. There's times it sort of overlaps with other rules. Obviously you have to bring in the actual murder weapon. You can't just bring in a similar type of gun and say this was the type of gun used. That's not the best evidence. If you have the gun, you have to have the gun. And if you don't have the gun, you're probably not going to have a case in the first place. And what the last slide just said there was, if the original contract has been destroyed, a Xerox copy is fine as long as there's no dispute that it's an actual copy of the contract, because that can be authenticated by the parties who were involved in the contract. Just like a photograph is a copy of something that occurred, but it can be authenticated by the people that were there at that time. Just a final little note on the evidence rules. That was a lot of law school level stuff, honestly. And it can get super interesting, but it can get even so much more complicated. But for purposes of working in the legal field, having that lens to view information available when investigating a case, having that lens to understand what might or might not be usable in court and valuable, is really beneficial to help structure and guide your preparation of a case. But one little final point is that even if you think testimony or evidence that you really want to use might be excluded under one rule, take a few minutes to try to get creative. Is there maybe another rule or exception that might let it in? So if your first instinct is, oh, this is hearsay, let me file it over here, it's not going to help our case. Take a little time, especially if it's important, and try to get creative and look at the other evidence rules and see if there's maybe an exception or a non-hearsay use that might let you use some or part of that evidence. And that's going to be impressive if you have that ability to do that. So those were two really long chapters. The next two, I'm pretty sure, go by pretty quick. Chapter 8 brings us back to earth a bit. Practical skills. Very different type of content here. It's almost so non-substantive that it's hard to make interesting, and really there's not much I need to add. I mean, you're not going to have any problem understanding what chapters 8 and 9 are communicating to you. But they're important. They're just important in a different way. These first few slides are pretty common sense. Written communication is important, should be accurate, should be professional. The same goes for verbal communication, and all of these types of communication are going to exist when working in the legal field. They all need to be accurate and professional and particularly thorough. The section on nonverbal communication is kind of interesting. Controlling your own body and your own body language, picking up on body language of others that you communicate with. Might be less obvious on how it's important to a case, but it definitely can be. When interviewing a client or a witness, you're writing down their answers or you're typing up their answers, you might want to notate significant body language they're using. If every response is defensive and arms crossed, defensive posture, they are not wanting to be there and it's obvious. Or if they're notably nervous and sweating. If you see a lot of confused expressions, even after you try to restate your questions, if you're concerned that they even understood you, language barriers, it's important to write down a lot more than just the words that you're being told. Those can be particularly important to a case, especially if it goes to trial and you've got that type of witness that has some baggage. But you also need to be aware of your own body language. The interviewee needs to feel that, that you respect their time, that they came in to talk to you. They want to feel accepted, important. They need to be motivated to fully participate in the interview and answer the questions that you're asking. So you might be exhausted and you might be on your 10th interview of the day. You don't want to let that come through. It could impact the answers that you get. Netiquette is also pretty common sense, but again, so important. We are all definitely more casual when we text or message our friends or our family. But you do have to shift gears in the workplace and remember not to use those LOLs or other abbreviations that just sometimes accidentally slip off the fingers and hit send before you take a minute and step back and read it for professionalism. So proofread outgoing emails or texts just like you would a letter. Double check for autofill. I mean, that thing really can mess up your content sometimes. It definitely doesn't always behave. Remember to use a professional sign-off that you wouldn't normally use, not casual. And kind of a step away from this, but equally relevant, is watch your public social media content as well. Your personal internet or social media behavior can definitely impact your professional life. Almost anybody I interact with today, whether it is a parent on one of my kids' sports teams, if I need to know more about them or have any concerns, or I'm sending my kid over to their house, I'm going to look them up and see what I can find out on the internet. And if you are working for a law firm that a witness has to interact with, or your client has to interact with, and your client is going to hire this law firm, it's likely they're going to do some of that internet sleuthing on their attorney and the attorney staff as well. So you do have to be real careful what you put in social media and make sure you understand how to use those privacy settings. In this section as well, there's a lot of common sense, not a need for me to rehash these things. I think there are two especially important takeaways in this particular section of the textbook. I've always been a note taker, but I remember going through law school with people who never took a note and they did amazing. So I suppose some people have that skill, but unless you literally have one of those photographic memories, always take notes while in a conversation. Try to remain attentive to the conversation, but there are certain things you need to make sure you jot down, dates or locations, things that the memory might fail you and you might not remember precisely. Our memories have a tendency not to remember larger groups of information like numbers and addresses. And it's better to occasionally jot things down during an interview than have to call that person back and say, oh, I forgot what you told me. You don't want to be writing down the whole time, so it's definitely kind of a balancing act. But it's better than having to bother that witness again who already came in and talked to you. And so then they're thinking, wow, they didn't bother even remembering what I told them. And they're also feeling annoyed that you keep contacting them. So that's something to remember. And also don't guess. When answering, let's say you're answering your attorney who asked a question about the witness or the interview, whatever you've been working on that day. Unless you're 100% sure in your memory or your notes, don't ever guess the answer to someone else in your office. That one's pretty important. Double check before risking sharing incorrect information with anyone. Just like on the internet. So many people think, well, this looks accurate, I'm going to share it. It's just been shared and reshared and reshared. And there could be an error. There could be an issue. Even if it's not a big one, it's more important to make sure that you don't share inaccurate information. I did not write this textbook, obviously. I think this is kind of a cheesy little acronym, but it's in here, and each step of this is important. When you're obtaining information about a case, conducting an interview, whether it's in person, by phone, Zoom, however it is, an investigator, as part of a law firm, a legal investigator, which is the role of either a partial or full role of pretty much all paralegals at some point. This acronym may help you to not forget any of these steps, right? We talked about listening, and you have to do more than just hear them. You have to listen what they're saying, understand what they're saying, but at the same time, take those notes, observe. We talked about the body language issue, not just at the tone of their voice, their ability to speak clearly or their ability to speak at all. I mean, those things need to be known by the attorneys because they have an impact on whether an attorney is more likely to settle a case or go to trial. If you have, a dozen clear-speaking witnesses who have no biases, wow, that's great. You're going to go to trial on that case, but that doesn't happen very often. You've got one hostile witness, and you've got one witness who hears voices, and you've got one witness who didn't have their glasses on when they observed whatever the legal incident was. You're always going to have some hurdles to overcome, and you don't want to find those out last minute at trial. The law firm needs to know all of these things, and that means observe everything. Evaluate. So when writing notes, make sure you're also jotting it down and highlighting or identifying things that just don't seem to add up. So if a witness is telling you things that don't seem to add up, rather than just handing that summary over to the attorney, you might need to investigate your concerns about that. If you can dig deeper somewhere in the evidence or another witness to figure out why there are inconsistencies, that's going to be helpful. That needs to be done. And then report. Don't ever formally report these types of summaries until you've evaluated every piece of information and associated legal issue that you've discovered. If that's your job, and if you are an active paralegal doing paralegal work, which is legal work. I mean, it's not just, administrative work. You have an education that's teaching you to conduct legal analysis. So even though you're sometimes doing tasks like interviewing someone, you're doing it through a lens of a legal professional. And so use those skills and use the brain that you have to make those connections and help, or become an attorney. That's exactly what they do. But they're going to rely on paralegals to do that, because with a good education, you can do that. And with a thorough understanding of all of these laws and rules that you're learning. And I think legal evaluation is interesting. It's not easy, but it's interesting to keep looking and trying to find those connections to exceptions to the evidence rule or to some other law that might help your case. So all of these steps really can allow you to come up with the best summaries and conclusions during your investigative phase when you're assisting on a case. Yeah, we talked about that. So finally, we've got Chapter 9. I like Chapter 9 because I'm a big planner, and I was never a fly by the seat of my pants litigator. I was a big planner with binders and tabs. Being spontaneous is fine if you're fully informed and you have that skill. I saw some prosecutors who were amazing at being spontaneous. But for me, planning was part of my ability to be my best in the courtroom and being fully informed and prepared and effective. All of these traits are really so important to being a successful and skilled investigator, legal professional. I mean, some of them are redundant, but it's not really surprising that they all sort of apply to the types of analysis that we've already talked about tonight. I mean, you have to look closely, look twice, be flexible, be creative, be persistent. So this chapter talks about formulating a plan of investigation. So when an incident happens and you read about the incident, you don't just pick up a phone and in no particular order start calling witnesses. You want to take the time to organize how you're going to approach that investigation, because different types of cases are amenable to different types of investigations. And the textbook kind of explains to you about that. You have the freedom to organize your investigation into a case usually however you want, but Chapter 9 has some really good suggestions, practical suggestions, organizations, even forms. It's always wise to start by compiling all of your legally significant facts. So you want to have that first. You want to have that summary. You may want to have it in chronological order. You want to have all your sources cited and available, contact information. You may have already notated whether you have concerns about credibility of any of the witnesses or any of the evidence. But beyond that, where do you start? That's really the question. Where do you start? In this part of the textbook, here's an example of how to chart that initial summary and organization. And whether it's in this form or a different form, it's important to have these sections indicating what you know, what information you have, what information you still need, whether that information is reliable or needs further exploration, skepticism. You want to look at it from your view, but also from the opposing counsel's view. Do you see a way the opposing counsel can prove that you have evidence or testimony that is biased or conflicting? You need to look at it both ways, and that because they're going to do that. They're going to try to discredit your case. So you need to do that before they do, to see if it's fixable or to see if you need to focus on some other aspect. In the context of both applicable law and the facts that might be missing, what do you still need to learn? Make sure you have all of those blanks obvious so that you know what blanks to fill. You need to know all of the who's and the when's and the why's and the where's and the what's of everything that you still need to learn about what happened on that day and that time and that legal situation that led to the dispute that led to this case. So then where do you get all the information that might be missing from your initial summary? The textbook talks about all the possible sources of information that you might start with. So you've listed everything you brainstorm one more time. What else do I need? So I'm going to have to reach out to people, more than likely, and to research, more than likely. Some of these sources, depending on what you need, if you just are missing a date or zip code, you might be able to send an email or a quick phone call to patch up your incomplete summary. But for some of the witnesses, you might need to conduct a full interview or a re-interview, depending on what point you are at in the investigation. You might even need to visit places or go visit and examine items and evidence. If you haven't been able to get a witness to appear and talk to you, you may have to meet them somewhere. You may have to accommodate them. You may have to go to a government office to view public records in person. Now, often you can order them online, but locations vary. So depending on where you live, it may be quicker and more efficient just to go to the office, the public records office of a branch of government, and look, depending on when you need it. Sometimes you send a request for information, it gets lost, or it takes months. So lots of different things that you want to notate on your plan of action. What's going to take the longest to obtain, what your deadlines are. Personally, I am a pretty linear and chronological person when I organize my to-do lists or my investigations into being thorough on a legal case. But I did find this part of the textbook interesting because it explains why that sometimes that's not the most logical way to approach a given case. Chronological or linear is not always the most effective plan of investigation. Because you can kind of think about it this way. If I do that and just go step by step, but some of those steps go back to the same location or go back to the same witness, then I'm making multiple trips to a particular source of information. But if I had planned the investigation using the sources format, which is one of the formats talked about, then it would have been more efficient. It would have been less repetitive, might have annoyed some witnesses less often. So the textbook does a good job of explaining when these different formats for investigation might apply, and it's worth taking the time to try to understand that logical explanation. It does a pretty good job. But regardless of how you organize your investigation, you do really want to create some kind of chart. These cause of action charts are really good because it lists all of the elements of the law that applies to your case. And that is the crux of any case, are the elements of the law established. So you list those elements and you identify what evidence and testimony you have that speaks to each part of the law, to each element of the law. And then that can also show you what's missing, what you still need to find, or who you still need to talk to. And in a perfect world, you have unlimited time and unlimited funds to complete this type of absolutely comprehensive investigation for every piece of potential evidence that you've identified. And you want to build this, like, super tight and indestructible case argument and bulletproof evidence, for lack of a better word. But in real life, there are limits. There are time limits. There are financial limitations. So you also have to use that lens when evaluating your plan of action. So if you have 4 eyewitnesses in your case, and they were all standing in the same spot and all saw the same thing, and the initial report doesn't really show you any red flags or any reason to believe that there's more information that they have, and you've been able to contact and interview 3 of them, but the 4th one moved to Alaska. Is your firm going to fly you to Alaska to attempt to find this 4th witness when you've got 3 credible witnesses from that same vantage point? Probably not. You may want to see if possibly they saw one other little different thing that the other 3 witnesses didn't see. But in real life, there are probably financial limitations, deadline limitations, and the firm is going to have to make that decision. How pivotal is this witness? How much is this case worth? Is settlement a good option? In which case, we're definitely not going to spend the money until we've explored settlement. So all of these things are really on a case-by-case basis. So when you read this chapter about different ways to attack your legal investigation of an incident that has occurred and why certain types of plans apply differently or apply better to different types of cases, this is why, because it's going to be a case-by-case analysis. Most law firms practice all different kinds of laws, all different kinds of law. Very few specialize just on one type of law because they've got to make a living and you've got to have clients coming in. So someone may do family law and criminal law. Someone may do property law and estates and trusts. And so you've got these different types of cases that are coming through the office, and they might each require different approaches in terms of organizing and investigating. And that's a case-by-case analysis. You don't want to assume what worked for a previous case works for a very different case, because you want to take the time to step back, think through what you've learned as to setting up your case summary and your next steps as to what is most logical for the case that's in front of you at the time. But the only other little thing that you still have to keep in your mind is those real world limitations. You may want to do everything, but your deadline is in 60 days and your budget is, X amount of dollars. We talked before about chain of custody and authentication of evidence in the context of criminal case evidence? A private law firm does actually have similar obligations when it comes to authenticating evidence. So if a private law firm has an item of evidence in its possession, has obtained an item of evidence, there needs to be a process in place to ensure a chain of custody, so that that firm can authenticate that evidence if it wants to use it in court at a later time. I always try to think of like daycares. When my kids were little, those daycares were like Fort Knox. You had to sign in, sometimes show ID until they, really knew you. You don't get to walk through rooms with anybody else's children. You get directly to your child. They are experts at checking in and checking out kids, knowing who is bringing that kid and who is taking that kid and at what time and from what entrance, for good reason, right? You lose a kid, you pretty much lost your business. So if a law firm can develop that level of expertise when it comes to creating an evidence log process and an evidence storage process, if their client or a witness brings an item of physical evidence, law firms need to have that, and they'll train you. Depending on where you go to work, you'll be trained in evidence procedures. And it's important, and now you understand why. It's important that that system is followed and that it excludes the possibility that an item is not what it claims to be, and excludes the possibility that that item was tampered with. This is just one example that is pretty simplified, but an example of an evidence log that might be used. Ideally, once something is placed into secure storage, it's not touched or looked at again until a trial date is set. But sometimes experts have to examine the evidence, or the opposing party has requested permission to examine it. So regardless of what little thing happens to that evidence, there needs to be a very clear documentation, and then whoever documented that becomes the custodian, the property custodian. So that employee needs to be a available and skilled, potentially testifying witness. So that's another thing to think of when a law firm decides who's going to be the custodian of the property. So frankly, you do have a lot to cover content-wise this week. But if you're watching this at the normal time or on the normal day, it's just Monday of week 3, and you have the rest of the week to do that. You do need to complete that interview assignment. That is the assignment for week 3 that'll be due at the end of the week. So try to get that started as soon as possible, because that's one of the types of assignments you can't really put off because someone else is involved, right? Make sure that, and also you have to not just complete the interview, you have to save time to get your summary completed and proofread, etc. Make sure you read the assignment instructions carefully and the rubric. That'll help you plan your written submission. And the rubric is really the best way to know what the expectations are of any of our assignments. So always feel free to go visit the rubrics. The discussion board is also part of the coming module. There are always some interesting articles that are submitted and discussed this week, so I look forward to that. Some people probably have already started early. So I'll look forward to taking a look in that discussion board and see how it's progressing. But the big thing this week is just the amount of reading. Not all of our weeks are going to be like this, but these topics really did go together. I mean, you can't do one half of the evidence content and then not the rest. So chapters 6 and 7 really were the bulk of the reading for the week. So hopefully this gives you a preview of chapters 6 through 9 and the content that you will encounter there. As always, if you have any questions or concerns while you are reading the assigned readings or working on the work for week 3, please feel free to shoot me an email. And even though it's a school holiday, it's not going to delay me getting back to you. I still should be able to get back to you within a day, at most 2 days, to try to answer any questions you might have. So if you made it all the way through this recorded lecture, I'm impressed, because it's a tough thing to do when it's not an interactive course lecture. But there's a lot of content here, and hopefully I've helped explain the topic of evidence and the hearsay rule a little bit more than just trying to read it for understanding.